everybody, welcome back to a new post today, and let's today discuss the week 2 with regard to polity and governance for UPSC 2026. Let's start with the very first issue, and that is about what is the Palermo Protocol and what does it speak about. This protocol, which is called as the Palermo Protocol or the United Nations Protocol to prevent, suppress and punish trafficking in persons, especially women and children, defines trafficking as recruitment, transportation, transfer, harboring, receipt of a child for the purpose of exploitation. Now, child trafficking remains a deeply disturbed reality in India, and Supreme Court in its recent decision of KP Kiran Kumar versus the state has given strict guidelines to prevent such offences and held that trafficking grossly violates the child's fundamental right to as guaranteed in the Indian Constitution, along with other rights like Article 24 and 23 as well. Now, according to the National Crimes Control Bureau, in 2022, 3,098 children below 18 years were rescued. Between 2024 and 2025, 53,000 children were rescued from child labour, trafficking and kidnapping across India. However, the conviction rate remains very low, just 4.8%. Along with the Palermo Protocol, we have Section 143 of the Bharatiya Nyaya Sanhita also providing a definition for trafficking. The word exploitation is wider in scope and includes physical and sexual exploitation as well, and it includes other form of slavery, servitude and forced removal of organs as well. The Constitution provides extensive rights for children, especially Article 23 and 24, which give them protection from human trafficking, begging, forced labour, employment and hazardous industries. Apart from these provisions, the state is also obliged under the directive principles of state policy to ensure that children are not abused and that they are given opportunities and facilities to develop in a healthy manner and conditions of freedom and dignity, which is specified in clause E and F of Article 39. The Bharatiya Nyaya Sanhita also addresses selling and buying of minors. Other acts which deal with trafficking and also sexual exploitation include the Immoral Traffic Prevention Act. Then you have the Juvenile Justice Care and Protection Act of 2015, the Criminal Law Amendment Act of 2013, the Protection of Children from Sexual Offences Act of 2012. And apart from that, we also have judicial approach in the Vishaljit versus Union of India in 1919. It said that trafficking and child prostitution are serious socio-economic problems, and hence preventive and humanistic approach is essential to deal with them. In the MC Mehta versus the state of Tamil Nadu in 1996, the court issued guidelines with a view to prohibiting employment of children in hazardous industries. In the Bachpan Bachao Andolan versus Union of India case of 2011, the top court issued the guidelines to address widespread exploitation and trafficking of children. The strong union-state relationship is required for dealing with the menace of trafficking in India. Now, Stalin, the Chief Minister of Tamil Nadu, has flagged interference in the Sahitya Academy Awards by the Centre and instituted new literary awards called as Semmozi Literary Award, which will be given every year, and it will carry a cash prize of 5 lakh for each language of Tamil, Telugu, Kannada, Malayalam, Odia, Bengali, Marathi. Speaking at the function of the International Book Fair Festival, he said that the announced to cancel the Sahitya Academy Awards of 2025 just few days ago is a matter of interference in cultural sphere. Now, let me tell you, Sahitya Academy Awards are India's second highest literary honour, conferred annually by Sahitya Academy, also called as National Academy of Letters, established in 1954. It recognizes outstanding book of literary merit in 24 languages, including 22 languages in the 8th schedule of the Constitution, as well as English and Rajasthani. The winners of the Sahitya Academy Award are given a copper plaque and also a cash prize of 1 lakh rupees. The first recipients are 1955 Makanlal Chaturvedi for Hindi, for Him Tarangini, and R.P. Sethuppillai Tamil for Tamil Imbam. And the recent recipients of 2024 include Samir Tanti, Assamese poetry winner, and Esterine Kair for English novel as well. Now, the announcement for 2025 of the main awards has been unexpectedly deferred, and in December 2025, the Ministry of Culture directed the Academy to announce the review of selection process to ensure compliance with the new MOU regarding restructuring of awards. Aside the main Academy, the Sahitya Academy Award, the Academy also presents various other prestigious honors like Sahitya Academy Fellowship, Yuva Puraskar, Bal Sahitya Puraskar, and Translation Prize as well. NatGrid, or National Intelligence Grid, has been in news, especially amid the push by Ministry of Home Affairs to all the police departments in the country to actively use this NatGrid, primarily intended to deal as a counter-terrorism tool. It is an intelligence sharing platform and has proved instrumental in dismantling organized crime networks. The master-based database NatGrid, conceived in the aftermath of 2008 Mumbai terror attacks, contains important information at least from 21 organizations. It stores information on tax records, bank accounts, financial transactions, immigration, vehicle ownership, toll payments, and even train and flight bookings, among others as well. It also provides single window access to FIR registered at police stations across the whole country, and the NatGrid has aided the Delhi Police and many other police in various states to help investigate high-profile cases as well. Now, an arbitration council bill has been brought about, and it was in news recently. So after 6 years, or after the 2019 amendments, the union government is yet to constitute an arbitration council of India, now envisaged as a central regulatory and promotional body for institutional arbitration. Recently, however, in 2024, union government released the draft arbitration conciliation bill of 2024, calling for public comments. The draft bill seeks to give fresh impetus to the institution of arbitration through a series of structural reforms. It introduces a revised definition of what an arbitration institution is actually, as a body or an organization that conducts arbitration proceedings under its aegis and in accordance with its own procedural rules or otherwise. It marks a departure from the 2019 amendments, which require institutions to formally be designated by the Supreme Court or High Court as arbitration institutions. The bill also proposes to expand the role of arbitration institutions by vesting in them the powers that currently lie exclusively with the courts. These include authority to extend time limit for making an arbitrary award, reduce arbiters' fees where delays are attributable, and substitute arbiters. If enacted, these measures are expected to reduce judicial intervention. However, in March 2025, responding to a question in the Parliament, the Union Law Minister Arjun Ram Meghwal said the bill was still under consideration. Now, how does it restrict judicial intervention? Under the 1996 Act, Indian courts are empowered to grant interim measures to protect the rights and parties of the parties in the arbitration. At present, such relief may be granted before or during the arbitrary proceedings and even after an award is rendered, but before its enforcement. The draft bill seeks to recalibrate this role by limiting the court's power to grant interim measures to the period before arbitration commences or after the award is rendered. Therefore, another significant proposal is introduction of Section 9A, which would allow the parties to seek interim measures from emergency arbitra once arbitral proceedings have commenced, but before the constitution of the arbitral tribunal. According to the BN Justice Sri Krishna report, the continued dominance of ad hoc arbitration in India is primarily attributable to strong preference for procedural autonomy. This preference is further reinforced by persistent skepticism towards domestic arbitral institutions, particularly with respect to independence and administrative competence. Bridging this trust deficit is critical if Indian institutions are to revive the established global bodies. And Magh Mela, a spiritual festival in Uttar Pradesh, is taking place during the holy month of Magh, January and February. It is a 45-day pilgrimage where millions of people gather for bathing at the confluence of Ganga, Yamuna and the mystical Saraswati rivers. Now, the Kuki-Zo Council and other community leaders are demanding for a separate union territory, with a legislature for the Kuki-Zo in Manipur. Mass rallies have been carried out in this support, and this comes in news when the government is now planning for the government formation in Manipur after the president's rule. Now it has been 1 year since the president's rule has been imposed. However, the Kuki-Zo are adamant on having a separate union territory with the legislature for them, because they speak of the government being dominated by the Meiteis and overlooking their rights and interests as well. The Kuki-Zo Council argued that the ethnic violence in 2023 has made coexistence with the Meiteis in the plains next to impossible. They also blamed the Meiteis for taking over hill regions of the Kuki-Zo and also citing 250 deaths and displacement of 40,000 community members. Manipur has been under the president's rule since February 13, 2025. The centre is currently attempting to restore an elected government, but the support of the 10 Kuki-Zo MLAs is crucial for the credible transition. Meitei Naga organizations continue to support the demand, arguing that this threatens Manipur's territorial integrity. And a plea for passive euthanasia is now being looked into by the Supreme Court. Ashok Rana has sought passive euthanasia for his son Harish Rana, who suffered head injuries in 2013 and has been bedridden and on a vegetative support system. The Supreme Court has reserved its judgment later for January regarding a plea for passive euthanasia for Harish Rana, who is in permanent vegetative state. Harish Rana suffered irreversible brain damage when he fell from the 4th floor of his building in 2013, and he has been bedridden since then. Both the Primary Medical Board and the Secondary Medical Board of the All India Institute of Medical Sciences, New Delhi, concluded that his recovery is negligible and has no scope of returning to normal life. The bench included J.B. Pardiwala and K.V. Vishwanathan remarked that they cannot keep this boy in the stage and noted the delicate nature of deciding on a person's life. The centre supported the plea, arguing that withdrawing futile medical intervention is not killing but allowing the nature to take its course. The case is being considered under the landmark judgment of the Supreme Court in 2018, called as a common cause judgment, which was modified in 2023. It legalized passive euthanasia, that is withdrawing while life support for a terminally ill patient to make death gradual, and also recognize living wills, allowing individuals to give advance medical derivatives regarding their end to life's care. It also prohibits active euthanasia, that is directly injecting a lethal substance to cause a person to die, which remains still illegal in India. And about passive euthanasia in India, let me tell you that passive euthanasia means withdrawing life support system, and it is legal under the strict Supreme Court guidelines from the Aruna Shanbhag case of 2011 and the common cause case of 2018, recognizing the right to die with dignity inherent in Article 21. While active euthanasia remains illegal in the country, key aspects including advanced directives like living will for the terminally ill patients or the permanently vegetative state patients, simplified procedure, and a 2-board review before giving the permission for passive euthanasia. The Aruna Shanbhag versus Union of India first recognized passive euthanasia for persons in a permanent vegetative state, allowing withdrawal of the life support system. Common cause versus Union of India affirmed the right to die with dignity and introduced the concept of living wills for future incapacitated patients. The 2023 guidelines, Supreme Court simplified living will procedures, removing the requirement for judicial magistrate and allowing notarization or gazette officer attestation, and proposed integration with digital health records. How does it work? The person must be terminally ill or in a permanent vegetative state and no hope for recovery. A person, while competent, creates an advance directive specifying their wish to refuse life support, and a primary medical board explains the connection to family or a guardian. A secondary board validates the decision, and the High Court then approves the decision for withdrawal of the life support system. Passive euthanasia is legal in India. There is no particular law. Under the Supreme Court guidelines, active euthanasia is still illegal. It is considered as culpable homicide or murder. And despite rulings, complex procedures, legal hurdles persist. Parliament is yet to pass comprehensive law with regarding to this, leaving implementation reliant on court directives and also health ministry guidelines as well. Now, the UGC has brought out guidelines against caste discrimination called as Promotion of Equality in Higher Education Institutions Regulation, introducing strict mandatory requirement to combat caste discrimination in colleges and universities. All higher education institutions must implement an Equal Opportunity Center and an Equity Committee to address discrimination complaints Every equity committee must be chaired by the head of the institution, must include members from SC, ST, OBC, persons with disabilities and women. Institutions are required to set up an online portal and 24/7 equity helpline for students and staff to report incidents safely. A major shift from the previous drafts include other backward classes are now explicitly included under the definition of caste-based discrimination. Institutions must investigate complaints quickly. The equity committee must meet within 24 hours of a complaint and the head must act within 7 days of receiving their report. The regulations shift from advisory norms to enforceable law with severe consequences for non-compliance. Also, withdrawal for grants or debarment from UGC schemes if these are not implemented. Institutes will be prohibited from offering degrees and online distance learning programs as well if found not implementing the guidelines. The UGC can remove an institution from its official list of recognized colleges as well. The rules follow Supreme Court directives issued after petitions concerning systematic discrimination in campuses, and the provision to penalize false complaints was removed to prevent discouraging victims, which critics argue may lead to misuse. And some critics argue that the rules create a bias by excluding general category from the definition of victims, potentially impacting campus harmony as well. And finally, what exactly is the Malayalam Language Bill 2025 brought in by the Kerala Assembly and made news with regard to neighbouring Karnataka? It establishes Malayalam as a sole official language of the state. It seeks to replace current dual language with both Malayalam and English sharing official status. The Malayalam now will be mandated for all government correspondence, circulars and notification. Malayalam will become the compulsory first language in all government and aided schools up to class 10. Judgments and course proceedings must be translated into Malayalam in a phased manner. And the IT department is tasked with developing an open source software and digital tools to ensure government websites and apps are natively function in Malayalam. The Personnel and Administration Reforms Department will be renamed as Malayalam Language Development Department with a new directorate established to oversee transition. And the recent criticism is about the linguistic minorities in the state with regard to Tamil, Kannada and Tulu and Konkani, who still correspond with their government officers in their native languages in designated areas. And the students whose mother tongue is not Malayalam can pursue their studies in those chosen languages which are available. Non-Malayalam speaking students from other states or countries are exempted from the Malayalam exams in higher classes. And despite the safeguards, Karnataka government has opposed the bill, calling it unconstitutional. They argue it will affect the Kannada speaking minorities in the Kasaragod district of Kerala by linguistically isolating the students who currently study in Kannada as their first language. And the bill is awaiting the governor's assent. So these are the most important news I thought I should be discussing with you for week 2 of January 11th to January 17th. If you did, please do like, share and subscribe, and don't forget to comment at the end of the video. I shall see you in my new post. Until then, it's very happy learning.